to suspend its members. Just at a cursory glance of the application to intervene when compared to the main application, Mr. Mawere does not deal with the challenge to Rule 25.70, which is what is squarely before us. The main application, as will become evident, deals with 25.70. And while the relief that Mr. Mawere would seek if he was allowed to intervene may well be relevant and may well be valid to members of the ANC, I'm not sure if it's of the kind that warrants adjudication in this urgent application. However, be that as it may, the application of Mr. Mawere is opposed by the ANC. It's opposed on three bases. Firstly, it is argued that the application is not urgent. Secondly, the point is taken that on Mr. Mawere's own version, he launched proceedings to challenge his suspension in 2013, and those proceedings are still pending, and therefore this court cannot be invited to allow him to intervene in an application where ultimately he seeks relief in respect of his own suspension and has brought proceedings to challenge that suspension and has not done anything substantive in the past few years to prosecute those proceedings. And finally, the ANC opposes the application on the basis that Mr. Mawere does not have a direct and substantial interest in the main application, which would justify his intervention. So much so for the application of Mr. Mawere. In addition to the application for intervention, there is also an application in terms of Rule 7 of the Uniform Rules of Court brought by Mr. Mawere, in terms of which he challenged the authority of the Deputy Secretary-General of the ANC, as well as the authority of the attorneys, Ledwaba Mazwai. In particular, Mr. Mawere disputes the authority of the respondents to oppose the intervention application, their authority to appoint Ledwaba Mazwai to represent them, and then finally the authority of Ms. Yasmin Jesse Duarte to depose to the answering affidavit on behalf of the ANC. I'll deal with the Rule 7.1 application before I revert to the intervention application. In support of his stance in challenging the authority of the respondents in terms of Rule 7, Mr. Mawere purports to rely on the constitution of the ANC, and in particular to clause 12.2.19 thereof. For the sake of completeness, I'll deal with some of the broad features of section 12.2 of the constitution of the ANC. What it provides for is in the following terms, and I quote, "Without prejudice to the generality of its powers, the NEC shall have the power to institute and defend legal proceedings on behalf of the organization." That's in 12.2.13. And then it provides in 12.2.19, have the power in appropriate circumstances to delegate any of its powers to the NWC, the officials, or Secretary-General. Mr. Mawere has argued that the use of the language appropriate circumstances must mean that whenever the ANC is challenged in litigation or whenever it elects to litigate, the NEC must convene, take a decision whether to institute or defend those proceedings, and then, in appropriate circumstances, delegate its powers. His argument is that there could not be a blanket delegation and that the term appropriate circumstances must be interpreted to mean that the delegation must be case specific. And when asked, he was of the view that, in his view, it would mean every time litigation ensued, the NEC would be required to meet. That was the first challenge on the basis of his Section 7.1 application. In addition to that, he contended that even if the NEC was allowed to delegate the Deputy Secretary-General's powers in terms of Section 16.9 of the Constitution of the ANC, would only be activated in the absence of the Secretary-General. In other words, if there was no Secretary-General in office, his view was that the office of the Secretary-General would effectively come to a halt. And when asked what would happen from a practical point of view, his view was that the organization would then have to meet and would have to deal with that eventuality. Simply put, he disputed that there was any basis for the Deputy Secretary-General to act on the delegation in the light of Section 16.9 of the ANC's Constitution. In opposing the application for intervention, the ANC Deputy Secretary-General filed an affidavit, and in support of her contentions that the ANC had properly authorized the NEC and that the NEC had properly delegated its authority to the Secretary-General and to the Deputy Secretary-General, she relied on the very same provisions of the Constitution to which I've made reference, and those are self-explanatory, but for the sake of emphasis, it provides expressly in 12.2.13 that the NEC shall have the power to institute and defend legal proceedings on behalf of the organization. And then importantly, in 12.2.19 gives the power to the NEC to delegate any of its powers, and that must include the power to institute and defend legal proceedings to the officials or the Secretary-General. In support of a contention that the ANC acted in terms of the powers granted to it in terms of the Constitution, she then placed reliance on a resolution passed by the NEC of the 18th and 19th of January 2018. That resolution is attached to an answering affidavit in the Rule 7 application. And that resolution reads as follows: noting that Rule 12.2.13 of the ANC Constitution confers upon the NEC the power to institute and defend legal proceedings, that it is impractical for the NEC to exercise this power as a structure which meets periodically, that the NEC is desirous of delegating this responsibility to the Secretary-General and the Deputy Secretary-General as full-time administrative officers of the organization. The resolution then goes on to resolve that the NEC delegates to Elias Magashule, also known as Ace Magashule, in his capacity as Secretary-General, and Yasmin Duarte, also known as Jessie Duarte, in a capacity as Deputy Secretary-General of the ANC, the authority to institute and defend legal proceedings.
Privatization of ESCOM, but basically it's good
of the ANC
ESCOM.
Sorry, sir, I wondered if you would please mute your mic. Thank you. I'll simply read the resolution again. It says, it resolves that the NEC delegates to Elias Magashule, also known as Ace Magashule, in his capacity as Secretary-General, and Yasmin Duarte, also known as Jessie Duarte, in a capacity as Deputy Secretary-General of the ANC, the authority to institute and defend legal proceedings on behalf of the ANC, to sign all documents necessary in that regard, and to instruct attorneys and advocates to act on behalf of the ANC. So that delegation is clear and it's unambiguous. And to the extent that the applicant, Mr. Maweru, relies on what would be appropriate circumstances, it is a general delegation. It is a blanket delegation in every sense of the word. And the question that he raises is whether that is appropriate. In this regard, I think it's important to point out that our courts have recognized that a voluntary organization is largely regulated by the agreement entered into between its members, which is reflected in its constitution, and that it must at all times act in accordance with that constitution. That being the case, the internal affairs, to some extent, of how a voluntary organization manages its affairs is largely left to it. And if the NEC, for the reasons given in its resolution of January 2018, placed on record that it was inappropriate, inconvenient, and perhaps even impractical for the NEC to meet on every occasion to take a decision on litigation. And if it elected to delegate those powers to the Secretary-General and the Deputy Secretary-General, then that's a decision that must be respected, and there's nothing in law that suggests such a decision is impermissible or that it falls outside of the NEC. So the challenge on this leg must fail. On the second part of the challenge, the court must interpret section 16.9, and it reads, the Deputy Secretary-General shall assist the Secretary-General, deputize for him or her where necessary, and carry out the functions entrusted to the Secretary-General by the National Conference, the NEC, or the NWC, and shall be an ex officio member of the NWC. The court has to interpret this clause in a way that's efficient and businesslike, and to align oneself to the interpretation of Mr. Mawera would mean that the organization would effectively be rendered dysfunctional in the absence of the Secretary-General. The language used in section 16.9 is clear. It says the Deputy Secretary-General shall assist, deputize when necessary. And clearly, if one reads section 16.9 together with the resolution of January 2018, which is in clear and express terms, the delegation, notwithstanding 16.9, was made to both the Secretary-General and the Deputy Secretary-General. And in the absence of the Secretary-General, there could be no bar to the Deputy Secretary-General acting on the powers given to her, both in terms of section 16.9, but also in terms of the resolution of January 2018. So for that reason, the second leg of the challenge must also fail. Finally, Mr. Mawere suggested that in the light of his challenge brought in terms of Rule 7, his application for intervention remained unopposed. I just wish to comment briefly on that as a matter of principle, that even if an intervention application is unopposed, the court has a duty to examine the unopposed application to satisfy itself that a proper case has been made for the intervention or not, and to make a determination one way or the other. The fact that an application is unopposed does not divest the court of its judicial responsibility to bring to bear its judgment on the facts and the law and to make a proper determination in every case. If that was indeed the case, then every unopposed application brought before our courts should be granted. And there are thousands of those applications happening every day. In its duty to dispense justice, even in unopposed applications, and perhaps even more so in unopposed applications, the duty of the court is a heightened one. That being the case, and given that the respondents have successfully challenged or successfully met the challenge to their authority, the application in terms of section 7.1 must be dismissed with cost. And that brings me then to the main application for intervention. I've already dealt with the facts, and I simply wish to briefly deal with the legal principles that must guide the court in the intervention application. Firstly, an application for intervention must demonstrate a direct and substantial interest. And in the Constitutional Court judgment of SA Riding Association for the Disabled versus the Regional Land Claims Commissioner at 2017, Volume 5, SA 1CC, the court expressed itself as follows in paragraph 9 of that judgment. I quote, "It is now settled that an application for intervention must meet the direct and substantial interest test in order to succeed. What constitutes a direct and substantial interest is the legal interest in the subject matter of the case, which could be prejudicially affected by the order of the court. This means that the applicant must show that it has a right adversely affected or likely to be affected by the order sought. But the applicant does not have to satisfy the court at the stage of intervention that it will succeed. It is sufficient for such applicant to make allegations which, if proved, would entitle it to relief." So clearly the bar in an intervention application is not simply an interest, but a direct and a substantial interest. I'll come back to this if it is necessary. The intervention applications have also been opposed on the basis of urgency, and it may be necessary to say a few words about urgency. While it is trite that Rule 12, which deals with interventions, provides that an application for intervention may be brought at any time, the fact remains that an intervention is sought by way of application, and therefore the provisions of Rule 6 of the Uniform Rules of Court would apply. If an applicant, as is in the case of all three applications for intervention before us, wishes to bring the intervention application by way of urgency, as they've sought to do, then the rules that relate to urgent applications must be complied with. And this is not simply for the sake of compliance, but so that the court can manage its affairs in an orderly fashion, and that the rules that relate to urgency and that relate to getting the attention of the court are effected and interpreted in a manner that is fair and just to everybody. In this regard, the applications for intervention all have to establish that the interventions are indeed urgent. I pause to mention that none of the applicants are allowed to ride on the back of the urgency advanced by the main applicant in the main application. The case for urgency will be dealt with when we get to the main application, but each applicant has a duty to satisfy this court that its application is indeed urgent. And in this regard, this court in Khoza versus the Minister of Defence 2020, Volume 5, SA 490, paragraph 18, made precisely that observation, that the application for intervention, if it is brought on an urgent basis, must satisfy the requirements of urgency. And that would simply put mean that the applicants must demonstrate that they approach the court at the earliest available opportunity. They must set out why the redress they seek needs to be adjudicated upon urgently, and that if it's not adjudicated upon urgently, they will not be able to obtain substantial redress in due course. If the applicants fail to do this, then the risk they run is that the application stands to be struck off the roll on the basis that it's not urgent. So, having regard to those principles, I then proceed to deal with the application of Mr. Mawere. There are a number of insurmountable problems that the application presents. Firstly, the relief he seeks, which may be relevant in the bigger scheme of things in how the ANC relates to its members, relates to a declaration that the disciplinary proceedings of the ANC are unconstitutional and ultra vires, and it seeks a declaration that the NEC and the lower NEC does not have any powers to suspend. There is no reason why that relief cannot be adjudicated upon in due course. There is no reason why that relief needs to be adjudicated upon in the context of this application. And in support of urgency, all he really says is that he heard about this case in the media and decided to seek intervention. There is the additional problem that Mr. Mawere faces, and that is that his 2013 case appears to be still pending. And in the context of urgency, one must question why he did not seek to bring the applications that he says he seeks declaratives at any earlier stage. Under those circumstances, we are not satisfied that a proper case has been made out for urgency, not so much in terms of his delay, but more in terms of whether there is an urgent need to adjudicate the relief that he seeks in the event the intervention is granted. Accordingly, we intend to make an order striking his application from the roll with costs. That's so far as Mr. Mawere's application is concerned. The second intervention application is brought by 5 applicants, Mr. Pule Patrick Ntene, Mr. Tabang Lawrence Nkoke, the Fisile Dabi region of the ANC, the Arthur Pitso branch of the ANC, and the Jomo Maruma branch of the ANC. In that application, the applicants all describe themselves as good standing members of the ANC, and they seek to intervene in order to advance the following relief. They seek to challenge the constitutionality of Rule 25.70. They also seek to have resolutions 2 and 3 of the resolutions of the 55th National Conference of the African National Congress held in December 27 declared unconstitutional and unlawful, and they also seek in order to have all decisions of the NEC or the NWC based on the resolutions 2 and 3 of the December 2017 conference set aside. In addition to the main relief, they also seek ancillary relief. And it's clear from a perusal of the relief that is being sought, while there's some commonality in terms of the challenge to Rule 25.70, the other relief is of a wide, general, and may I say, far-reaching nature. The ANC opposes the intervention application, and they do so also on the basis of urgency and also on the basis of their contention that the applicants lack a direct and substantial interest in the manner required by our law. They also take issue whether the applicants that constitute the region and the branch have legal standing to bring the intervention application. Now, on the question of urgency, the applicants in this intervention application allude to that in their papers, where they pose the question why they waited so long to bring this application. I may point out that in advancing their case for intervention, they say that they don't bring this application in order to support the application of Mr. Magashule, but they bring it as a matter of principle in the interest of members of the ANC. And so reverting to the question as to why they waited so long, they say that they waited for the implementation of the resolution of the National Conference by the NEC, and when it was evident that that resolution would be implemented, and they say amended as well by the NEC, they thought it necessary to bring this application to seek the relief of the court. If this indeed is an application brought as a matter of principle, then there is no explanation why it was not brought earlier. The resolutions in question started in approximately August last year and were refined in March of this year. There is no explanation why there was a delay in all of that time in bringing this application. On another level, and also related to urgency, given the quite different relief that is being sought by these applicants, I'm also not satisfied that a proper case has been made out as to why this court needs to, on the basis of urgency, have to adjudicate the relief that they seek. That relief may well be dealt with in the fullness of time by another court. And in that regard, we're not satisfied that a proper case has been advanced in respect of the urgency of this application, and intend to make an appropriate order in that regard. I then proceed with the third and the last application, and that's the application of Mr. Ntando Yenkosi Shezi. Mr. Shezi also describes himself as a member of the ANC and says he supports the relief sought by the applicant and he seeks to intervene on that basis. But he also says that the stance he takes is a stance supported by thousands of other members, but nothing is provided in support of that. But be that as it may, one must consider the application on the basis that he is a member of the ANC and comes to court in that capacity. The application for Mr. Shez's intervention is also opposed on the basis that it's not urgent and that he does not have a direct and substantial interest. Now, in response to the answering affidavit filed by the ANC in this intervention application, the applicant filed the briefest of replying affidavits, in which it said that the answering affidavit of the ANC was, properly speaking, not before the court. The court was then therefore entitled to ignore it and to deal with this application on an unopposed basis. I already commented on the duty of the court in dealing with applications, even if they are unopposed. But for the reasons that will follow, I certainly don't agree with the applicant's contention in this application that the application is unopposed. And I'll briefly deal with the contentions of the applicant with regard to his stance that the affidavit of Ms. Duarte is not properly before the court. What he says is that in her affidavit, she says she has personal knowledge of the facts, but she does not go on to say that they are true and correct. And on that basis, he says that her affidavit is fatally defective. In support of that argument, he relies on the judgment in the matter of Galp versus Stanley, NO 1966, volume 4, page 555 at page 558H. I've had the opportunity to look at that judgment, and what that judgment deals with is really the question of hearsay allegations in an affidavit. And the judgment deals with statements based on information and belief. And so to that extent, I'm not convinced that this judgment is applicable and is authority for the proposition that a deponent to an affidavit must state that the facts to which the affidavit is deposed to are true and correct. Does that mean that a deponent can then depose to facts that are not true and correct? Obviously not, because an affidavit is only an affidavit when it is attested. Before that, it remains a statement. And when it's attested to and the oath is taken, it becomes a solemn assurance of fact, as the writers remind us. And in taking the oath, the deponent to an affidavit swears that what she deposes to is true and correct. It's binding on her conscience. And therefore, even if in the body of the affidavit there is no language to the effect that what is being deposed to is true and correct, it must be evident from the affidavit itself and the attestation of that affidavit, which is not challenged in these proceedings, that the statement is elevated to a solemn assurance of fact. And therefore, the challenge to the affidavit is certainly not sustainable in my view. Accordingly, we approach this application on the basis that it is properly opposed. The applicant has elected not to file a replying affidavit or to file substantial heads on the basis of the point it has taken, which I've already dealt with. And so I proceed to then deal with the question of urgency. In support of the argument of urgency, all the applicant states is that this application must be dealt with expeditiously. That is a reference to the main application. He has advanced no submissions with regard to why his intervention application is indeed urgent. All he does is to make common cause with the relief sought by the applicants. It adds no new material to the material that the court is required to deal with in any event in the main application. And for those reasons, the application falls considerably short of the bar set in dealing with applications of an urgent nature. In this regard, I think it is important to simply observe that in substance, all of the intervention applications were brought after the date of the 1st of June, and that date is relevant because that is the date on which the original main application was enrolled for hearing. That while they may raise issues of relevance to the membership of the ANC in their relationship to the organization, we're not satisfied that in any of these cases a proper case has been made out for urgency, nor are we satisfied that any of the applicants have advanced any cogent argument why the relief that they seek cannot be adjudicated in the fullness of time, and accordingly the applications fall to be dismissed. I would then make the following order. In the intervention application of Mr. Mawere, the challenge in terms of Rule 7 is dismissed, and the application for intervention is struck from the roll with costs, including the cost of senior counsel. In the interne matter, the application for intervention is struck from the roll with costs due to non-urgency, including the cost of senior counsel, and in the Shezi matter, the application for intervention is struck from the roll due to the lack of urgency, with cost, including the cost of senior counsel. That concludes the judgment on the intervention applications.
As the court pleases.
I agree.
I agree. It is so ordered. Okay. Okay, that brings us then to the main application, and Mr. Mbofo, are you ready to proceed?
Yes, indeed, my lord. My lord.
Mr. Mbofo, I sorry to interrupt you.
Yes.
I wasn't sure if we needed to do any timekeeping, but it seems that we would have enough time to get through the arguments, and you obviously take on board what we said this morning with regard to us having read the papers and the heads, and we'll really focus on the issues in dispute. Would that be an appropriate way of moving forward then?
Yes, my lord, I would, and given the outcome of the intervention applications, if maybe, my lord, at least it's now 11:45. I will certainly not have been finished by lunchtime. So what I propose we do is we start, my lord, and then during the lunch break, we will try, maybe with my learned friends, to do an allocation. If we don't agree, we'll come back to the court. I think that might be a practical way of dealing with it. In any event, we'll also have a sense, I think, from the interventions or non-interventions of the court as to how much time we might need. As the court pleases.
Okay, good, Mr. Mpofu.
Thank you. My lord, well, before I start, I just received instructions that I must register some concern that we have on our part about the issues that were dealt with in respect of the intervention application. We're just placing it on record that we do not regard it as appropriate to have dealt with some of the merits of the issues that are still going to be dealt with in the main application. For example, the issue of the interpretation of Rule 16.9 and all those issues about the power of the Secretary-General, because that gives an impression that those issues have been prejudged before they've been argued in the main application. And as I say, it's an impression, one that I may or may not share myself. But the point is that our approach would have been maybe, especially in respect of those issues, to simply, I don't know, maybe if the interveners might have objected, if it simply had granted the order, so that those issues are dealt with at the end, once argument has been heard on them, regarding the issue of of the authority of the DSG. I'm not placing it any higher than that. I just don't want I don't want anyone to say we're raising it belatedly, maybe when we are dealing with those issues. But it's going to make our life difficult to try and unconvince a court rather than one that we think is coming with a clean mind on those issues. I'm just registering it, but I'm not making a big issue of it at this stage.
Thank you, Mr. Mpofu. I mean, you will agree that the issue of 16.9 was also dealt with by this court because it was raised by the parties and the court was duty bound to do so. But secondly, it was also dealt with in the context of a resolution of 2018, which was a distinguishing feature in certainly the argument that you might want to make. Okay, but we note what you've recorded. Thank you.
Thank you, my lord. But between me and the court, I'm assuming that the court will still be open to persuasion on even those issues that it has pronounced upon. Obviously, otherwise there'll be no point in even raising those arguments. But I'm assuming that that is the case.
Thank you.
Thank you.
Hello.
Sorry, Mr. Mpofu.
Yes.
No, Justices, I just wanted to be certain that we can be excused so that I'm not walking out. Can be excused.
Mr. Sikakane, you're welcome to stay, but if you have to leave, then you're excused.
I have to leave. Thank you so much.
Okay, thank you, Mr. Sikakane.
Once bitten, twice shy. My lord,
we did not hear that, Mr. Mpofu.
I know, my lord, my lord. On a more serious note, I'm actually reminded by what Mr. Sikakane said. I have instructions to make a request to the court around access to these proceedings. I see that there are more than 100, about 130 people who are part of it. But given the public interest and some of the constituencies that have a direct or indirect interest who are in remote locations, we would like the court to consider either now or even during the break, whether or not some regime, and maybe Justice Mulahle will help us, because I understand he's the expert on these matters, as to whether the access cannot be made more open. In other words, those who want, I think there is a maximum number, but at least those who are able to connect should be allowed, because we have been receiving reports that people were correctly told that they could only access when if they have permission to do so.
Yes, people can actually access, and as I recall, the discussion we had with the secretaries was to open up the court to the maximum numbers that may be. And if I may just indicate to you, Mr. Mpofu, we had a discussion yesterday at court to see what could be done, but the challenge is the COVID restrictions. So it's very difficult to do, because one of the things that you could have done if it was not for the regulations was to just have a venue where you could put a television and then link them to one laptop or so.
Yes.
But because of that challenge, that's where we really are. But so far, I've seen a number of people joining. So if the space is still available on the platform, people could join.
Thank you. We're indebted to the court, yes. In fact, the permission was really because people were asking us for the link, and we didn't want to give them a link without the permission of the court. Thank you. We're indebted to the court.
Okay, thank you, Mr. This is a public hearing, so I think the link can be shared widely, subject to it reaching a particular ceiling. Correct.
Yes. Thank you.
Yes.
Thank you very much. Right. Thank you. My lady, my lords, then coming to the issues of the day, we would like to seek the guidance of the court in respect of the approach, but obviously we will suggest a particular approach, and then the court may amend it or adjust it or agree with it or disagree.
Mr. Mpofu, is that, sorry to interrupt you, is that in respect of the application to strike and the condonation?
Yes, in fact, let's call it the preliminary issues broadly versus the merits. Yes,
Yes.
That's what I'm alluding to, Justice Kolapen. And we have made an indication. The issue of the amendment and agency and all that has fallen away because there's no opposition to those issues. But the issues that are still alive are the issues of condonation and Rule 615. So I would assume the court would like to deal with those issues up front. If I'm correct in that assumption, then we will, in terms of signposting, we will then deal with those issues. After that, obviously, we will then go into the merits, and I will advise the court at that stage how we propose to split that up or even to approach it again in a broad fashion. But if I could, with respect, get indication from the court that that is the approach.
Thank you, Mr. Mpofu. It would seem to me that, and subject to what my colleagues and Mr. Trengove may have to say, that if you dealt with condonation and the striking out application and then immediately proceeded with the merits, we wouldn't need to hear the condonation and the striking out as separate insulated applications. But we would hear you on all of it and then hear the respondents on all of it, and we would make those determinations at the end of the matter, as opposed to, yeah. Is that what you're suggesting?
Yes, my lord, that makes sense. So, yes, as far as, no, I'm not talking about stop, start, and then replies and so on, because that will waste time. I was simply saying in terms of approaching it, that we start with the preliminary issues and then go into the merits, sequencing. The reason for that will be clear, my lord, just now, because one of my colleagues is going to be arguing the Rule 615, but I'm going to deal with the condonation. So I just wanted to get the sequence right.
But I assume my colleagues are in agreement, and Mr. Trengove as well. Yes.
Agree?
Yes, we do agree.
Good, thank you. Good, Mr. Mpofu, you may then proceed.
Thank you, my lord. Well, my lord, then let me start with the issue of condonation, and I'm not going to waste a lot of time on this, my lord. I simply want to point out that, you know, the respect of our courts is something that must not be taken for granted by any litigant. We are of the firm view, my lord, that the litigants in this particular litigation are maybe operating on the basis that you know, the courts have different rules for different people, and it is our respectful submission that that notion must be immediately and summarily dealt with. All people who come before our courts are the same. Whether they are kings or paupers, they must be treated in the same way. And every day in our courts, litigants are told, even if you are late by 1 day, you must, condonation is not there for the taking. You have to seek the indulgence of the court. It's not for you to say, well, it's just 1 day or 2 days. It's for the court. And that's a matter of respect for the courts more than anything else. Now, we have here a situation where the litigants in question have flagrantly disregarded the very well-known rule that in urgent application...
We're going to come out of that process. I want to know what you made of that quip by Advocate Dalimpofu about once bitten, twice shy in relation to Advocates Kakani and that famous state capture situation where him and former President Jacob Zuma were said to have walked out. Well, there you have it. All the judges in agreement to that interesting start to the two-day process where Elias Magashule, also known as Ace Magashule, approached the High Court to resolve his suspension as the ANC's Secretary-General. The process started by dealing with an application for interventions by several people, but Mr. Mutua Mawere, the High Court's judge, Jody Kolopin, says the matter has been dismissed with costs. Mr. Mawere is part of the ANC structures and members who approached the courts for an application for intervention or to intervene in the suspension of the Secretary-General Ace Magashule, saying that the organization would be rendered dysfunctional without the SG. That application has been dismissed with costs, with Judge Kolopin saying Mr. Mawere's application is not urgent and that he doesn't have a direct interest in the current case of the SG. Mr. Mawere lodged an application with the court to listen to the matter of his suspension from the ANC in 2013 and how it relates to the suspension of the SG Ace Magashule. Mr. Mawere himself was expelled from the ANC in 2013 for allegedly defrauding the National Lotteries Council using the ANC's letterhead. The judge also goes on to into the application of other members in good standing of the ANC who want to challenge the constitutionality of Rule 2570, on whose premise Mr. Magashule was suspended. And another ANC member, Ntando Shezi, also made an application. Mr. Shezi's contention that the application of Rule 25.70 was inconsistent is also found to be neither urgent or sustainable. The relief that they seek dismissed, and application for intervention struck from the roll with costs. Well, the process continues, of course, but that's it from us here from the